I'm going to click record on that.
Okay, I think you guys should all be able to see the presentation. Can you see it? Okay, great. All right, well, we'll go ahead and get started. Thanks, Andrea, again for the introduction, for the presentation or for the recording. This is the ethics for City of Mercer Island officials. I'm Eileen Kiefer of Madrona Law Group. Like Andrea said, I'm your outside legal counsel. I'm officially your assistant city attorney. B.O. Park is your day-to-day, everyday city attorney, but I have a dedicated number of hours that I also provide to the city. And so both of us are here as a resource if you have any questions either tonight or going forward on ethics issues. Okay, we're going to introduce you to a couple of different legal concepts here, but most specifically to the specific code of ethics for Mercer Island. And since I am a lawyer, I have kind of a lawyerly disclaimer I have to give at the beginning of all of these, which is that taking this training, while required, is not a defense against any ethics complaint that you receive. And hopefully none of you guys receive any. But I just have to note that I'm going to give you the best information that I have. But ethics issues are so fact specific that they're always going to be really contingent upon the official's best judgment, since you guys have all the facts related to your particular circumstances. And we'll start generally with, why does the city even have a code of ethics? And that's pretty straightforward, right? It's to make sure that Mercer Island residents and businesses and the general public maintain that trust in the local government. We're going to go over, like I said, a couple of different regulatory schemes. And so one of them, and the one we're going to talk the most about, is the Mercer Island specific code of ethics. That's contained in the Mercer Island City Code at chapter 2.60. I note that the chapter was heavily revised, in fact, almost rewritten last summer. So we've had about a year to work through it. So I'll note, I don't know if any of you have served as board or commission members in the past. That's why I know the revision date in case that you are familiar with maybe the previous code of ethics. I note too that the city's code of ethics is supplemental to other law, including the RCW for municipal officers. It's chapter 4223, which relates to code of ethics for municipal officers. I'll note that the statute is the floor, the way they work together. The statute's the floor, and then the city code goes beyond what the statute requires. And the code of ethics is pretty broad in application. It applies to city council, to you all as board and commission members, and to other council appointed task groups or committees. Expectations of city officials. So this slide and the next slide just captures what the code of ethics says that it expects of you all as city officials. And frankly, I am not going to read all of these out to you. What I will do after this presentation is I will send the slides to Andrea. And she'll send those around so you guys can, review those at your leisure. I should have mentioned that earlier. I try not to give out slides in advance, so that way you guys can kind of just take it in and listen and kind of, just take it in that way without having to worry about like, oh, where are we at on the slides? So like I said, these two slides go over what the expectations of city officials are, and they're pretty straightforward, right? Like honoring and respecting the principles and spirit of representative government. The big one is conducting your official and personal affairs so that you maintain public confidence in city government, making sure that people know that you can't be improperly influenced, being independent, impartial, and fair, in being honest, fair, and respectful, and avoiding conduct creating appearances of impropriety. As we get into this, we're going to start with kind of a list of do nots, which really relate to like self-dealing, conflicts of interest, and making sure that you are serving the city as opposed to getting an unfair financial gain by result of your city position. Okay, so prohibited conduct. We are going to get into, like I said, the list of do nots. And this portion of the presentation is going to be pretty definition heavy, which I do apologize for. There's just kind of no way around it. That's the way that your ethics code is written. But we're going to try to break that down as much as we can into kind of core concepts. But if I'm really, harping on definitions, it's just because they're really crucial to understanding what conduct is prohibited by the Code of Ethics. So just know, this one's, I think, pretty straightforward until we get to the definitions, is city officials cannot have conflicts of interest. And if they have a conflict of interest in a matter that's before them, then they have to recuse themselves. And so this obviously means you can't vote on an item for which you have a conflict of interest. But it also means you can't participate in the discussion at all, which makes sense if you think about it, right? If you have a conflict of interest such that you can't vote on it, it stands to reason that you also couldn't, influence your fellow board or commission members on that same issue where you have the conflict of interest. I'm going to make a brief note here too about recusal in the Zoom era, right? Like we're on Zoom right now. What does that look like when we're not in a room all together, and where recusal doesn't look like leaving the room? There's a couple of different ways you could do this. I think one way you could do it is to, turn off your video and mute yourself, so that way, you're not participating in the discussion and you're not voting on the item. Another way, and I think perhaps a better way, would be even to, leave the meeting for the portion that you need to while you recuse yourself. And then a city staff member could text you when it's time to rejoin the meeting. So that's kind of what recusal looks like in a virtual world as opposed to in person. Okay, so what is a conflict of interest? So here we are at our first definition under the Code of Ethics. So an official has a conflict of interest when they themselves, their spouse, anybody who lives with them, or an entity for which the official is an employee, officer, director, trustee, partner, or owner, stands to incur a financial gain or loss relating to a city decision. I note too, for purposes of this definition, an owner is someone who owns more than 1% or more of the entity in question. Here we have an interlocking definition, right? The conflict of interest definition keyed off of financial gain or loss, and so you may be wondering, like, what does that even mean? And the Code of Ethics says, well, it means the material financial gain or loss that either an individual or entity stands to incur as a result of a decision under consideration by the city. What about things that you can't avoid, right? So like, let's say that your board or commission, maybe you're on the utility board, and you're a Mercer Island resident, so of course you pay utility charges on the island. Well, the good news is that's not going to be a conflict for you, because that's going to be either payment of generally applicable taxes or fees, or financial interest shared with more than 10% of the city's population. So this concept of financial gain or loss recognizes that just by virtue of you guys being Mercer Islanders yourselves, there are going to be some situations where you're just unable to avoid kind of falling into this financial gain or loss. So there is a carve out for those kinds of circumstances. Okay. So moving on past conflicts of interest to appearances of conflicts. So I think actual conflicts of interest, they happen, but I think they're a lot more rare than situations where it seems like, or it appears like, an official has a conflict. And that's the thing, is appearances of conflicts can also be damaging to the public trust. So the Code of Ethics says, has particular restraints on action if you have an appearance of a conflict but don't have an actual conflict of interest. So how do you know if you have an appearance of a conflict? And again, we're under another definition here, right? The code of ethics tells us there's an appearance of a conflict if it would appear to a reasonable person having knowledge of all of the relevant circumstances that the official's judgment could be impaired because of either a personal or business relationship or due to a transaction or activity engaged in by the official. So I know this is a lot more broad, right, than the definition of conflicts of interest, which is part of the reason appearances of conflict are a lot more common. So if you do have an appearance of a conflict, how do you treat that? What do you do? And the code of ethics requires you to make a public written disclosure of the facts giving rise to the appearance of a conflict before participating in the matter. So you'll recall for conflicts of interest, you can't vote and you can't participate in the discussions. So total recusal. Here, it's a written disclosure before participating in the matter. Now, if you want to recuse yourself, that would be going above and beyond. You're not required to do so, but I've seen officials do this just for appearances of conflict if they're really, really worried about how it would look. Okay, so moving on from the concept of conflicts of interest and appearances of conflicts, contracts. I don't know how often your boards or commissions are going to be reviewing or approving contracts. So this may vary based on, we have kind of a mix of folks here with different roles. So how often this comes up for you may vary based on the role you're serving. But know that Mercer Island officials cannot be beneficially interested either directly or indirectly in any contract that's made by, through, or under the supervision of that person in whole or in part, or that would be made for the benefit of his or her office. So this actually derives from the statute, and we're going to get into kind of some examples of beneficial interest in contracts. So, because I know this is kind of a legalistic definition. I also note too that officials can't accept either directly or indirectly compensation, gratuities, or rewards in connection from any contract from any other person that's beneficially interested in that contract. So the idea, I think you probably get the idea. It's simple. Is we're trying to make sure that officials are not self-dealing when they are reviewing or approving city contracts. Okay, so what is a beneficial interest? Beneficial interest is going to be any direct or indirect monetary or material benefit that comes to an official as a result of a contract or transaction that's subject of an official act or action by or with the city, except for any contracts that give similar benefits to all other people or property similarly situated. So again, we have a very legalistic definition here too, but you really want to focus on direct or indirect monetary or material benefit that would accrue to you as a result of the contract or transaction. That's going to be the key to a beneficial interest. Beneficial interest in contracts are prohibited. I should kind of back up and say, this prohibition means it means more than recusal. It means that the city can't form the contract at all. So that's how serious this is that if you have a beneficial interest in a contract, that it just can't be formed unless there's an exception or an exemption. We're going to get into that in a second. And then here too, I want to note that there can be some overlap between conflicts of interest and then the concept of a beneficial interest in contracts. And they require different things, right? If you just have a conflict of interest on a contract or, on something that's not a contract that you have a beneficial interest in, the city can still go forward with whatever that is that you have a conflict of interest in. You just have to recuse and not participate. But if you have a beneficial interest in a contract, then unless there's an exception or an exemption, the contract just can't be formed with whoever it is that you have the beneficial interest in. So caution's warranted. So that's a long legalistic way of saying, basically, if these things are coming up, probably call me or BO, or maybe even ask for an ethics advisory opinion we'll get into that later on in this presentation. Examples of beneficial interests. This is where I think it's probably the most helpful. I picked kind of the low-hanging fruit with respect to these because it's an easier way to understand these. And also too, I have picked on council for purposes of these examples, and no disrespect to council is intended. They're just the kind of the obvious ones to choose for these examples. So beneficial interest in a contract. So if council is looking at approving a professional services agreement to hire a council member's company as a consultant for the city, or maybe a contract for supplies to the city from a company owned by a council member's spouse, or last but not least, sale or lease of a land by a council member to the city. All of these would be examples of beneficial interest in a contract. Okay, so moving on to exceptions, which I alluded to earlier, there are exceptions to this prohibition against beneficial interest in contracts. There's a long laundry list of them. They exist in the statute in RCW 4223.030. I haven't provided you all of those because frankly, a lot of them don't apply to Mercer Island. They've applied to like smaller municipalities where you might not have as much contracting choice. But just if you have a situation coming up where you think you might have a beneficial interest, or you think you qualify for an exemption, again, please either ping one of us in the city attorney's office, or you can also request an advisory opinion from the ethics officer. If an exception to the prohibition against beneficial interest exists, then there's still, of course, a procedure to be followed. So if an official has a beneficial interest in a contract that falls under an exemption, then they have to recuse. They can't vote in the authorization, approval, or ratification of the contract, even if the exception applies. Additionally, the interest must be disclosed publicly and noted in the city's official minutes before the contract is formed. And as a best practice too, even though recusal here says no voting, my recommendation would be again to recuse before any deliberations, not just the vote, like you would for a conflict of interest. There are also exemptions, interests that are so small that they're essentially de minimis, and therefore not big enough to rise to the level of a prohibited beneficial interest. So those are called remote interests, and they're just kind of these minor interests, right? So like if you're a non-salaried officer for a nonprofit, if you're on the board for a nonprofit corporation, if you're a fixed wage or salary employee of a contracting party, so meaning you don't get commission. If you're a landlord or tenant of a contracting party, or if you hold less than 1% of the shares of a corporation or cooperative. So again, a remote interest is not a beneficial interest in a contract. But as with the exceptions, there is still a procedure to be followed. So any remote interests have to be, again, disclosed and noted in the minutes. The interested official cannot vote, and then additionally, the official cannot influence or attempt to influence any other officer of the city to enter into the contract. So that would be either in deliberations or even offline in conversation. Okay. I should pause. I'm going to pause here and just see if anybody has any questions. We've kind of gone through a lot. And that's okay. If you guys have questions too that come up afterwards, you can always just email me or Vito. Okay, we'll move on. The Code of Ethics also prohibits city officials from improperly using city staff time or property. This one I think is kind of a no-brainer for you guys, right? Is you're not really supposed to misuse city staff city equipment, city facilities for other things other than a city purpose. So fax machines. I don't know. It's been a long day, so I don't think you're going to be using the city fax machines often. City printers, city computers, city staff time. Just make sure you're generally using those for a city purpose. There is an exception for infrequent use at little or no cost to the city. The example I think that always springs to my mind is maybe you're issued a city laptop, and maybe occasionally you buy a shirt off of Amazon or something like that. You do a little online shopping. I think that's probably not going to fall under the improper use of city staff time or property under this exception. Okay. Representation of third parties in city proceedings is also prohibited. So this makes sense, right? You guys are serving in a particular role, and you're not supposed to be getting, special favors for yourself, your family, your friends. So officials are prohibited from appearing on behalf of the financial interests of third parties before the board or commissions that you serve on, or in any interaction with assigned staff. There's also a prohibition for members of city council. They can't appear on behalf of a financial interest of third parties before either of themselves or before any of your board or commissions or in interactions with staff. So an example of this would be maybe if you serve on the planning commission, you'd be prohibited from representing a friend who is seeking a rezone for their commercial development. Gifts and favors. I think this is going to be pretty straightforward. So we're going to go through kind of what's prohibited and then what the exceptions are. So as a city official, you can't take special advantage of services or opportunity for personal gain that aren't available to the public. So obviously you can't, ask for or get anything of monetary value if you know that it was given or asked for to get, special treatment, special consideration, special influence. I'll note that it's not election season yet, but election season is coming up. This prohibition does not include lawful campaign contributions. So for those of you who are anticipating a run for office, just know that that's exempted from the prohibition against gifts and favors. Exceptions, I'm going to kind of hit the high points, but not all of them. If you are, if you receive unsolicited flowers, plants, or floral arrangements, that's fine. If you get unsolicited advertising or promotional items of very nominal values, like a pen, maybe a pack of sticky notes, something like that, that's fine. Although if you're getting an unsolicited iPad or something that's of more than nominal value, then you are obligated to refuse that gift. Tokens, awards of appreciation, again, unsolicited, so plaques and trophies, that kind of a thing, that's fine. Informational material, publications or subscriptions relating to your official duties. I think the thing that comes up most, we're going to talk about food and beverages. I think that's the one that comes up just the most frequently. So if you're at a hosted reception as part of your official duties, then food and beverages are generally accepted. Similarly, food and beverages on infrequent occasions in the ordinary course of meals where attendance by the officials related to your official duties. I think, again, this comes up if you're, attending an event on behalf of the city, then you can attend food and beverages. I think the key for this exception too is the focus on infrequent occasions. So, maybe you go to this particular reception on behalf of the city once a year. I think that's fine. But if you are maybe, having lunch with a developer once a week and they're buying your lunch, I don't know if that would necessarily fall under the exception to this prohibition against gifts. So just kind of be careful when you're accepting things. And then finally, my favorite exception is, I think, the most straightforward, which is you can absolutely still get gifts from your family or friends where it's clear that this is just getting a gift because of your personal relationship and not because of your official duties. So if your brother knits you a sweater for your birthday, that is fine and clearly not prohibited by the Code of Ethics. Moving on to confidential information. Some of you, maybe not all of you, may receive confidential or attorney-client privileged information by value of your position. It might be attorney-client privileged. It may be just advance notice of maybe a piece of property the city is considering purchasing or something else confidential. It doesn't always have to be attorney-client privileged. Know that you can't disclose or use that information for anything other than a city purpose. And that pretty much covers the Code of Ethics prohibited acts. There are a few prohibited acts that the statute also requires. There's quite a bit of overlap, so I'm going to kind of hit the high points here. Obviously, as we've discussed, you can't use your position to secure special privileges or exemption for yourself or for others. The second bullet point really relates to gifts, and we've talked about gifts a lot, but just know that the Code of Ethics prohibits gifts or compensation, rewards for your official duty. Know that this is also prohibited under statute. The top bullet here, though, I think is where there is a little less overlap between the Code of Ethics and what the statute prohibits. I don't know what you all do for a living or what you guys do, you know, as part of, I guess, your civic life, but know that your employment or your business or professional activity can sometimes have conflicts with your role as a city official. And so know that the statute prohibits municipal officers from engaging in these activities if it would require you to disclose confidential information acquired by reason of being a city official. Okay. All right. Well, I'm going to move on now to the role of the ethics officer who I noted earlier. We're going to go over what he does. And I'll note too, the ethics officer is an attorney named Jeremy Columber. He's doesn't work for the city. He's like the third party ethics officer, but so that's who he is. And we're going to get into what his roles are. So the ethics officer has three main responsibilities under the ethics code. Doing prompt and fair enforcement of the Code of Ethics when called upon to do so, investigating sufficiency of submitted ethics complaints, and then finally providing advisory opinions for officials subject to the Code of Ethics upon request. And we're going to start there with the advisory opinions because I think that's going to be the most interest to you all. Okay, so as I said earlier, if you guys have questions about, you know, I want to do X or this vote is coming up, do I have a conflict of interest? Do I have a beneficial interest? What can I do? You can always ask the ethics officer, for an advisory opinion. That there's some constraints on that, right? You can only ask about hypothetical circumstances or situations relating to you, not to others. And the ethics officer can't render opinions on matters that are, you know, the purview of other government agencies or officials. So if you're asking about something and maybe it's a campaign question, then that's going to be a PDC question, and he'd decline to issue an opinion on it. Similarly, Public Records Act, that's not going to be something the ethics officer opines on. And I'll note that the ethics officer has the discretion to determine in what cases they'll issue an advisory opinion on. And when determining when to issue an advisory opinion, the ethics officer can consider, you know, whether the issue has been recently addressed by the ethics officer, whether it's an issue that's likely to be controversial or subject to dispute. And to the extent to which the requesting official has made prior requests for advisory opinions. And I note too, I mean, this is what the code says that the ethics advisor's role has been. I don't think I've yet seen him decline to issue an advisory opinion. And of course, too, the advisory opinion process isn't a substitute for the public officials' own understanding of the code of ethics and their exercise of reasonable judgment. And that's just because, again, like I said at the top of this presentation, you guys know the facts the best, and you guys know your own situation the best. I want to note here that if you are requesting an advisory opinion, the Code of Ethics gives the ethics officer up to 45 days to issue an opinion. That's a long time. You might need a decision much sooner, depending on, maybe something's coming up for a vote at a particular date. So if you need an answer earlier, I would strongly urge you to ask for that in your request for an advisory opinion, because he can and does respond more rapidly if the requester expresses urgency in the request. Okay. So reliance on advisory opinion. So this is why it's beneficial, I think, to ask for and receive an advisory opinion, is because if you do get an advisory opinion and it says, if you act in a certain way, it wouldn't violate the code of ethics. It's going to be basically a defense against civil enforcement of the code of ethics against you. And of course, I mean, that being able to rely on that is contingent on, having provided all of the material facts in the request to the ethics officer, making sure that the conduct matches up with what the ethics officer, put in the advisory opinion, and then obviously having the advisory opinion saying that the described conduct would not violate the code of ethics. Okay, I'm going to move now to the complaint process. I really hope that this is like the only time we ever go through the complaint process. I hope none of you guys are ever subject to it, but we're just going to go through how it works, just so you know kind of what that looks like. Know that any person can submit, doesn't even have to be a Mercer Island resident, can submit a written complaint to the ethics officer that alleges one or more violations of the code of ethics. They would do so by filing it with Andrea, the city clerk. The complaint would need to contain specific facts with enough detail for the ethics officer to make a determination of sufficiency. And it must contain the specific subsections of the ethics code that are alleged to have been violated. And then finally, the complaint must be signed under penalty of perjury. All of this is geared at trying to, avoid kind of frivolous complaints. Again, to avoid either, vague or frivolous complaints, the ethics officer, once getting a complaint, is going to first just make a finding of sufficiency. That doesn't mean necessarily like innocent or guilty or like did violate, didn't violate. It just means the ethics officer has enough to go forward with the complaint. So within 30 days of receiving the complaint, the ethics officer will make a determination that there's sufficiency to move forward. And a complaint sufficient if it precisely alleges and reasonably describes acts that constitute an on its face showing of a violation of the code of ethics, including the statute. Confidentiality, to the extent the city can, it will remain as confidential the fact that a complaint's been filed, the contents of the complaint, and the identity of the person making the complaint, as well as the identity of the official complaint against. I note that just kind of take this with a grain of salt, because know that the city is subject to Public Records Act, which might be other law that's accepted under this confidentiality provisions. Okay. So if the ethics officer, after making a determination of sufficiency, or even before, so there's a couple of ways a complaint can be dismissed. If the ethics officer figures out that the complaint is not sufficient, if the complaint provides too little detail for him to reach a determination, or if the ethics officer finds that, yeah, maybe the appropriate actions have been taken, or maybe a violation did occur, but appropriate actions have been taken to fully address the allegedly unethical conduct. So just know those are the three ways a complaint can be dismissed under the ethics code. The complaint is not dismissed, then it can move forward to a hearing so long as it was found to have met the sufficiency threshold by the ethics officer. Those hearings will be conducted by the city's hearings examiner. So again, that's a consultant who hears all of the city's typical appeals. Those hearings are, they're quasi-judicial hearings. Parties can present and cross-examine witnesses, give relevant evidence before the hearing examiner, and the hearing examiner will prepare an official record of the hearing. If the official doesn't want to go through a hearing, then they can ask the ethics officer to instead submit a recommended stipulation to the city council. And so the stipulation has to include the relevant facts, the reasons the ethics officer thinks the stipulation is appropriate, an admission of the violation by the official, promise not to repeat the violation, and if appropriate, a recommended remedy or penalty. If a stipulation is not entered and instead we go forward with a hearing, then within 30 days after the hearing is concluded, the hearing examiner will issue a final decision. And then there's like two ways that could go. So if the hearing examiner determines the alleged violation weren't proven, then he just dismisses the complaint and no further action will be taken. But if the hearing examiner determines that one or more violations are proven, then the final decision shall also contain any recommendations to the city council. And then the hearing examiner's decision moves forward to the city council. Within 15 days of the hearing examiner rendering their decision, Andrea will deliver copies of the final decision to the person who made the complaint, to the official who's subject to the complaint, to the ethics officer, and to the city council. And the city council is essentially, if you get to this stage, which we haven't had any that have gotten to this point, but if it gets to this stage, the city council makes a determination. So they can determine what, if any, of the hearing examiner's recommended remedial actions or sanctions to adopt. I note that their decision on this matter has to be done by a majority vote in an open public meeting. So when this is in front of city council, they've got a range of things that they can do. They can impose no sanctions or penalties. They can refer the matter to another agency with jurisdiction. So like the Public Disclosure Commission, if it relates to campaign finance or other campaign issues. They can issue an admonition, which is an oral non-public statement. They can issue a reprimand, which is a letter. They can censure the official, which means they would read a harsh letter, a stern letter to the official in public. They can even remove the official or impose civil penalties. Note that either the complaining party or the official who is the subject of the complaint can appeal city council's action on either the ethics officer's recommended stipulation or the hearing examiner's final decision by filing a writ of certiorari in King County Superior Court. And then finally, note that the Code of Ethics does contain a protection against retaliation. So neither the city nor any other official can take or threaten any action that constitutes a personal attack, harassment, or intimidation against any person because they file a complaint with the ethics officer. And with that has been, gosh, that went by fast. 40 minutes of ethics training. This was a lot. And like I said, this is not the sexiest of topics, but it's really important, right? Like you guys are public officials on behalf of the city, and you guys are responsible for shepherding the public trust. So I don't know if you guys have any questions, but feel free to ask. Mr. Becker, looks like you've got a question.
Yeah, and I have two questions, and if either of these are too specific to me, I'm happy to follow up afterwards. One is, earlier you made a comment about a conflict in terms of like people, I think it was people in your household.
Mm-hmm.
I just wanted to clarify, so the limitation is strictly to people who are in your household and not other people that you're related to. Like in my case, I'm related to a lot of people on Mercer Island, many of whom, like, I don't know what their scenarios are, and I don't even necessarily know what would benefit them.
Yeah, that's a great question. Let me go back to the slide in question, because I think you're talking about, it's either conflicts of interest or a beneficial. I think you're talking about conflict of interest. It's obviously going to depend on, what's in front of you guys, right? I think it wasn't appearance, wasn't it? Conflict of interest. Yeah, here we go. Conflict of interest. Okay. Yeah, so for conflict of interest, it's it's whenever you, your spouse, or somebody you live with, or an entity that that you serve as an employee, officer, director, yada yada yada. You're right. This isn't anybody you're related to. So if they stand to incur financial gain or loss, this has a more narrow scope.
Yeah.
But it could rise to the level of an appearance of conflicts, because remember, that's more broad, right? So personal or business relationship, that's where your other familiar relationships come into play. So,
and for the record, I don't want that. I was just trying to clarify, like I'm not trying to use that. And then my second question is that I am the owner of a company with more than 1% interest, and I don't have any specific business with the city, but I was unclear whether that meant that it like precludes my company from doing any business with the city whatsoever, or was that specifically related to things that go through the board that I'm on related to a decision that I make?
Yeah, so let's go back to that slide. That's a great question. I love the questions because they give, like, we're kind of talking about these like dry legal concepts, and when you start talking about like specifics, that helps. It helps me gel for me a little bit better. So. Okay. So let's see, 1% here. So remote interest, is that what you're talking about? I don't think that's what you're talking about. Oh, you're talking about, I'm sorry, Dan, you're talking.
And again, if this is too specific, I'm happy to follow up. I just didn't know if this is like subject to an official opinion.
Yeah. I see. You're asking about owner, because owner was an individual who owns 1% or more of the entity. Yes. So it really depends on what's before the city decision that's in front of you, right? So financial gain or loss related to a city decision.
So it's related to if I'm making a city decision, if I was to like sell marketing, like we make marketing materials. So like if I was to make marketing materials for the city for something totally unrelated to anything I'm voting on, that would be acceptable.
Yeah. So
and again, I can reach out to them afterwards. Why don't I reach out afterwards so that we don't take up everyone else's time?
I think that works good. I think that works really well. Yeah, thanks. Okay. Well, I'm not seeing any other hands. So if you guys have questions, afterwards, as this is kind of like percolating through your brain, or just as things come up, right? Feel free to, get in touch with me anytime. Feel free to call BO. I'm going to stop sharing. You guys have been a very patient and good audience today, and thanks so much for attending this evening.
Yes, thank you all for coming. If you have any questions, you can always reach out to me, and I can put you in contact with Eileen and BO as well.
Thank you.
Thanks, everybody. Enjoy the sunshine. Stay cool.
Thank you. Bye-bye. Thanks, everyone.